extension of interim order. Extension of interim order গুলো সব নিয়ে আসবেন as early as possible. Wait, he is senior to you. Yes. Give it.
On earlier also, there was a direction for the petitioner to file supplementary affidavit. Supplementary affidavit need to be filed finally. The matter is
What matter?
single revision.
Under the heading hearing?
No, exam.
Which court passed the order?
Honorable Justice Viwas Kanjan, important thing.
May I see the order? নিয়ে আসুন, একজন মশান তো কিছু বুঝতে পারছেন। লাস্ট অর্ডারটা তার আগে কি কি স্টেজে ছিল দেখে নিয়ে তারপর আমাকে দেখাবেন, তারপরে লিস্টিং করবো। For inclusion? Hearing? Hearing, criminal? Motion. I beg your pardon? I cannot follow. Huh? Hearing of appeal? Give this slip, SLC. Both the matters are there. Both the matters are the MSCC matters.
No, one is here and more push.
Very good. Any other mentioning? Call the list.
Number one, for the petitioner.
Why it is placed under the heading to be mentioned? What is can 1 for? কল্যাণ বাবু ক্যানটা কোথায় আছে? Possible. Come at 1 p.m.
My lord, I am appearing online, my lord. My lord, I am appearing, my lord.
Yes.
The extension of interim order, my lord. Interim order initially passed on, my lord, on 30th of...
What are the CRAN 2 and CRAN 3?
My lord, those are, my lord, extension of interim orders, I think, my lord. There is no can otherwise filed, my lord. This is CAN 3, my lord. That is a extension of interim order. The order was initially passed on 30th December 2024, my lord.
What is the stage?
My lord, this is for a quashing of a FIR. What happened is, my lord, the private respondent has purchased some equipments, my lord. We set up gymnasiums, my lord. They purchased some equipments, my lord, in a hire purchase from Bank of India, my lord. Bank of India is also a party over here, my lord. Now they have filed a FIR. They have secured a lesser amount of loan what they have expected, my lord. Now they want refund of money, my lord. Now they are saying I will refund the equipments, you refund me money. What is happening, my lord? If I refund the money and get those equipments, my lord, the bank will catch me. because those equipments are perhaps hypothecated to the bank. Now he has gone otherwise, my lord. Without settling with the bank,
Who is for the private respondent?
my lord, we have served, my lord. The private respondents are not appearing, my lord, since long, my lord. They have initially engaged a learned advocate, my lord. Thereafter, they have those advocates. They have. I
Wait,
think
wait,
they
wait,
have
sir,
not.
wait, sir, wait. What happened, sir?
Matter, time to accuse me. I have filed the application that matter, I think it has not been solved even.
You are the advocate on record.
I was the advocate on record, client asked the brief from the particular, this lawyer and came to me. All of a sudden, I don't know how they are again appearing. This client is actually a
You have
frivolous one.
filed Vakalatnama.
Yes, Vakalatnama with a specific mentioning that the lordship may kindly have the original one maybe. The advocate from the Calcutta is not giving the no objection, all these kind of things they have
My
written.
lord, the client has contacted me, my lord. This person is known to me, my lord. I have seen this matter
And must not be
to
this application is conducted by this court lordship.
my lord. There was no objection given, my lord. My lord, this is very embarrassing, my lord. I may
Probably
retire
the
from
first
the.
page, lordship.
Who is Mr. Abhishek Mittal?
Abhishek Shortcut, Ami.
Oh, I'm sorry, Ovilas Mittal.
My lord, Abhilash Mittal is somebody else, my lord.
Give me a second.
Petitioner's advocate on record.
Give me a
is
second.
Yes. All. My lord, Abhishek Mittal used to appear for the private respondent and is not appearing.
I request you to give me some time.
Yeah,
So if you are in a hurry, I can take up my matter on any other day.
no. I am not in a hurry, my lord. I am never in a hurry.
Who is Madam Priyanandi?
Priyanandi is my advocate on record, my lord, from Calcutta.
Then
She's
where is your Vakalatnama?
Lordship, I'll tell you.
Have you filed your Vakalatnama in the department?
Yes. Please look into the industry. This client is over smart.
Your client is Mr. Who is your client? Babu Rati.
Yes.
What's your good name, sir?
Abhishek Shortcut. Sometimes that's the.
But it does not bear advocate not giving no objection.
Lordship.
So by this way, Vakalatnama cannot be filed.
Lordship, that is.
Precisely, my
client
lord.
Came to me.
Your client has to write a letter to the advocate on record, previous advocate on record,
Right.
intimating that since he or she is not giving no objection,
Lordship.
you are asking him not to appear.
Actually,
Where is that letter?
that letter he has told me that you filed, that was the last day of the when his application supposed to be
No,
filed.
by communicating any letter to our previous.
That letter has not.
Please listen to my question. Prior to filing the Vakalatnama
Lordship.
through you,
Lordship.
has your client had written any letter communicating his previous learned advocate that he is no longer willing to appoint her as a lawyer, and accordingly he is terminating his power and he is giving Vakalatnama to a new advocate?
Lordship, that letter has not been given.
Then it will not be taken up.
Then this application must be also not be taken up. Lordship.
My lord.
At your instance.
This application has been filed by
How
me.
can you file Vakalatnama without no objection?
Very well, but the application is filed by me.
Which application?
This application for continuation.
This application was filed by Priyanandi, my lord. Priyanandi went there and filed it 3-4 days before. Kindly takes up the application. Can 3 probably?
Grant 2, Lordship. If grant 2
can 2 is over, my lord.
frivolously disposed of, Lordship, then. I am specifically alleging.
It has been disposed of by a coordinate bench.
Lordship, that there must be some frivolous thing is going on between the lawyer.
I am not recognizing you. You have no power.
My lord,
to
I will be
appear.
filing appropriate proceeding against
I'm very simple question.
Lordship,
Has your client issued a letter?
no, not.
Please,
Lordship.
it issued a letter to our erstwhile advocate, according to your erstwhile advocate, intimating her that he is no longer willing to keep her as an
No.
advocate, and he is requested or she is requested not to appear.
No.
No,
Lordship,
then I will not hear.
Lordship, kindly bear me a single minute.
I will not hear you for a moment. Don't appear.
But
At least in this
lawyer,
country.
client is doing frivolous thing with the court.
এটা রেকর্ড কর এটা
Mentioning this now, Lordship.
Yes, sir.
Yeah.
My lord, may I tell? Mr. Counsel is, my lord, this is very embarrassing. What
keep
happened,
your
my lord?
words
He is
outside
my
the court.
friend.
This type of, sir, I will not tolerate.
My lord, he is my friend for my.
Sir,
For-
the court is not there. The court, don't think that the court is deaf or dumb.
No, Lordship, I
have heard what you have said.
Lordship.
Whatever you intend to say, those are privileged communication. Go outside the court and do the matter. Don't make any disturbance.
Client.
My lord, very unfortunate, but my lord, he
Yes,
wants to
yes.
steal the brief, my lord. I don't know how this counsel
Otherwise, the
will,
matter is ready for hearing.
ready for
Otherwise,
hearing,
the
my
matter
lord.
is ready for hearing.
Yes, my lord. Kindly extend some time and my lord, specify a date, my lord, so that I can go there and personally do the matter.
If the matter be taken in Friday or the next Monday, the council appeal.
এই মামলা নেওয়া যাবে না এই যত ঝঞ্ঝটের জানিস আসুন
Any other day?
Tran 3 of 2025. In the meantime, I will hope that you will decide the dispute or settle the
My lord,
dispute.
I will not decide the dispute. I will go. I will tell the client to go to Bar Council of India, my lord. What has been done, my lord? I have
Very
chats,
good.
my lord.
Mute করুন, mute করুন. This is an Tran 3 of 2020. This is an application for extension of interim order.
My lord, only one. My lord, only one indulgence, my lord. My lord had extended it till my lord. The process was, as my lord was dictating, the process was stopped, so I could not hear
Till the last
How
day of
many-
September.
last year.
Till the last day of September 2025 or till further order, whichever is
Alright.
earlier. And it will
Alright.
be, listed in the next circuit under the heading contested application.
Oblige, my oblige.
What is item number 3?
Lordship, in item number 3, I am appearing on behalf of the appellant petitioner.
POCSO case, my lord. Section 4.
Extension of interim order.
Indeed, your lordship.
My lord,
my humble submission, my lord. My lord, more or less, my lord, case diary is required. My lord, kindly fix it on day after tomorrow, my lord, and final hearing may be concluded, my lord.
Which order is under challenge in the instant revision application?
My lord, the order that has been passed by the learned additional district and sessions judge 1 Shiliguri.
You want quashing or
My lord, quashing of the proceedings. That's
Why?
because- My lord, this is totally an engineered narrative that has been framed by the de facto complainant. And the
place your
petitioner,
case, place your case. Place your case.
My lord, medical is corroborating, my lord.
Let me
My lord, page 20 of
take,
the.
take your seat.
Mal- mal-
First place, allow him to place a case.
my lord, this is totally an engineered narrative where the de facto complainant, he has made the petitioner he has threatened the petitioner in such a way that the petitioner was in an intention to commit suicide. My lord, my lord, if you kindly look over the 164 statements.
First place the FIR. Written complaint.
The main application, my lord, in page number. My lord, in page number 130, in the written complaint.
Hmm. Place your case, sir.
My lord, here, the thing that has been written, that the petitioner, he has taken away the daughter from the de facto. The daughter has gone away with the petitioner.
Sir, I request
And-
you to place the FIR line by line. If you are not clear, I can say in
Like,
Bengali or Hindi. These three languages I know. I request you to place the written complaint.
Like in the written complaint, it has been stated that I, Shanti Das,
Yes.
wife of late Nantu Das,
Huh.
residing at Dokhin Bharatnagar, ward number 24, Shiliguri 734007,
Yes.
district Darjeeling, would like to inform you that my daughter, aged 16, born on 11/12/2008, was kidnapped on 26/7/2024.
Huh.
But after extreme pressure, the boy named Prabhat Das, son of Ganesh Das, residing at Raiganj, near Raiganj police station, returned my daughter on 18/8/2024.
Huh.
Now the problem is that the boy named Prabhat Das is threatening me and my daughter that he will commit suicide if I do not send my daughter to him.
Hmm.
It will be very kind if you please do the needful.
Hmm.
My lord, this is a false and a fabricated case that has been framed. Now, my lord, if you kindly come on to the
No, on perusal of the written complaint, my very specific question on perusal of the written complaint itself. Don't you why do you think that no prima facie case has been made out for initiating an investigation by starting a PS case? Why?
My lord, if you kindly look on to the 164 statements, that is starting from page number 15. Here something is written, like, if my lord kindly permit me, I would like to read out the statements that has been written in Bengal. My lord, here it has been written that on 8 এবং বলার পর 18/8/2024 তারিখে আমার মেয়েকে বাড়িতে দিয়ে যায়, মানে the
Come to page number 25.
the 25. Page number 25.
Yes. Yes, please. Come to the bottom. Come to the lower last paragraph of the page number 25.
My lord,
Such and such আমার বাড়ির কাছে থাকে। ও আমার টেলিফোন নম্বর যোগাযোগ করলে কথা বলতো, তাও প্রবাদ আমার ওর বাড়িতে 24 বছর আমাকে টাচ করে প্রতিদিন। So prima facie materials are there. Why quasi?
my lord, first I would like to say that this is the first time that I am addressing before
Sir,
your
forget
Lordship.
about first time, second
And
time.
I am being led
Just
by Mr.
satisfy why I will invoke my power for quashing. That I intend to know. Simple prayer. Take
My
down.
lord, then-
This is an application under section uh, 520 আমি দেখিনি। This is an application under section 528 of BNSS. Stop para. By filing the instant petition, the
The appellant conviction. The appellant has been convicted for imprisonment for 5 years. Under section 8 of POCSO.
Where is the judgment? You have annexed the order. Where is the judgment?
I beg your pardon, we had not only the ordering portion has been annexed.
Then
Leave may be granted to annex the judgment.
at the time of hearing, learned advocate, you are advocate on record.
My learned senior is that. She Shubha Shakti is that.
At the time of hearing, what's the good name?
Satyajit Kumar
Satyajit?
Pal.
Mr. Pal, learned advocate appearing on behalf of the appellant submits before this court that due to bona fide mistake, the certified copy of the impugned judgment has not been annexed with the memo of appeal. Full stop. He prays for leave to file the certified copy of the judgment. Stop. Leave as prayed for is granted. Paradin. Liberty is given to the appellant to file certified copy of the judgment. Certified copy of the impugned judgment dated 9/6/2025. As passed by the learned additional session judge, second court, Kujbihar, in connection with POCSO case number 92 of 2016. Within bracket লিখে রাখো POCSO trial number 04 within bracket 02 of 2017. Within 7 working days from today in the department. Stop. The department is directed to tag the certified copy of the said judgment with the instant file. Liberty to mention.
Great, great.
Next.
Ready number 5.
Oh, time for the conviction under section 448, 354, my lord.
In this appeal, the judgment and order of conviction I'm sorry. In this appeal, the judgment, yes, judgment and order of sentence dated 26/6/2025 and the order of sentence dated 27/6/2025. as passed by the learned additional session judge, comma, second court Darjeeling, in connection with sessions case number একটু দেখে নেবে sessions case number such and such arising out of such and such is assent. Stop there on perusal of the memo of appeal, including the certified copy of the judgment, certified copy of the impugned judgment and order of sentence. And after hearing the learned advocate for the appellant, this court is satisfied that perhaps there are sufficient merits in the instant appeal. Accordingly, the instant appeal is admitted. Stop para. Call for trial court record for at once. Department is directed
I am for the state, my lord. At 6.
Also, issue an application for quashing of the FIR as well as the charge sheet. The political animosity between two rival political groups culminated into the prosecution case. If your lordship kindly come to the charge sheet, my lord, page 23. That is after page
on
21.
perusal of the FIR,
Lordship.
no case has been made
My lord,
out
I am come.
for initiating a cognizable offense, for investigation of a cognizable offense. That
After page 21, man. That
Yes,
is
sir.
Certified for. But the,
on the basis of the written complaint,
yes, sir.
why according to you, you are thinking that no cognizance can be taken up?
The charge sheet will reflect something else.
So
A group of people, the entire prosecution case claims its origin from a political animosity between two rival political
maybe,
groups.
maybe.
If your lordship kindly come.
What is the infirmity?
Out of a pick and choose policy, several persons have been implicated in this the prosecution case. So far the charge sheet is concerned, the foolish they came to a conclusion my lord, that few person have been, my lord, segregated, they have been discharged, and few person have been, my lord, entangled, they have been charge sheeted. It reflects from the charge sheet, my lord. And my lord, so far, my lord, the allegation of, my lord, injury is concerned, my lord, that has been reflected. That is very simple. That has been, my lord, stated in the, my lord, the charge sheet. Almost, my lord, 34% have been implicated. Out of them, my lord, 17% have been charge sheeted.
Those are subject matter of trial, Mr.
Yes,
Mistro. Why the court will exercise power for
My lord,
quashing?
My lord, a group of person when, my lord, have been, my lord, implicated, my lord, if there is no specific allegation, my lord, they are specific, my lord, overt
They
act,
will be acquitted. If no material is found.
my lord, from the face
No,
of the
from the face of the record, no case has been made out for initiating, for taking
my
cognizance
lord,
of
kindly
the.
take, my lord, the charge sheet, my lord, once, my lord.
Place me, I am ready to take up.
Page, my lord, 25, my lord, the internal page, my lord, 25.
Yes, sir.
My lord, the third paragraph, my lord,
Yes.
my lord, the
Sir,
structure.
CD, please.
Yes, my lord.
Yes.
My lord, the line starts with, my lord, the IO. IO also collected. Yes, my lord. When the IO also collected certified copy of the history of the victim, Ishwar Chandra Devnath. My lord, who, my lord, this person was, my lord, the allegation reflects that this person was severely injured. She was the prime victim. Son of such and such, of such and such, was, my lord, admitted under Dr. Vivekananda Bera and was referred out of on ATO. IO collected injury report of the victim Arjun Chakraborty, son of such and such, he is such and found that he was brought Dihata SD hospital on such and such at about 15 hours and was treated by Aisha Khatun and reported that the nature of injury was slight in nature.
So 323 will come.
Yes, my lord, there is no specific allegation that attributed, my lord, that, my
Where
lord,
is the injury report, sir?
that encompasses the, my lord, the each and every person's, my
Page
lord.
25.
26, my lord. Arjun Chakraborty is page 26.
There is no specific allegation that this particular petitioners, my lord. A group of people has been, my lord, entangled, and my lord, allegation has also been labeled, my lord. There is no specific allegation. No overt act attributed, my lord, that has also been specified in the charge sheet.
Multiple incisive injury over scalp, right side.
Yes, my lord, that is the earlier paragraph, my lord. The investigation, my lord, doesn't show, my lord, any specific act, my lord, in respect of these particular petitioners. 34 persons have been entangled, my lord. 17 has been charge sheeted, rest has been, my lord, discharged.
This is an application.
Number 7.
I am appealing for the state, my lord.
CDB term লিখে দেবেন। Yes, Mr. Poddar, what is the matter? এই ফাইল দাও।
Mother lost something that her daughter is missing with the accused petition. Daughter is major, she clear. Her daughter, presenting is the daughter married the petitioner. They have current community and mother lost this complaint. She was kidnapped and on. There, I have also I have the marriage registration certificate and also
Where is the FIR, sir?
page my lord 10. It's 10 and also question.
Yes, Mr. Poddar. The victim is a major.
From the affair also, 20 class. Affair also stated, major lady, 20 class. Major lady married, have annexed the marriage registration certificate, and at the time of filing of the revisional application, the lady also affirmed being the wife, also stated.
Page number?
8.
Page number 8 is the affidavit page.
The Shaka Bormon is the daughter of the Vector complainant.
Annex the?
Marriage registration certificate.
Where is that, sir?
Page 11 of the petition, my lord.
So victim has been recovered.
My lord, in this case, my lord, as per the case diary, victim not recovered yet and the petitioner is still absconding, my lord. My lord, at this stage, my lord, they should have at least surrendered before the police and produce this document so that we can verify these documents. And my lord, we get the opportunity of recording the 164 statement also, my lord. This is the crux point, my lord. May I say one thing, my lord? Give him some interim protection and go before the investigation agency and produce those documents so that we can verify those documents. And also get the opportunity.
What interim protection?
Not as per the document, my lord, they are married. They got married.
They have different caste for this reason, my lord. Deciding separately. He also then, if your lordship directed, victim can come before the court also.
But the investigation agency has no record.
This is an
Why is the
application.
victim?
This is an application under section 528 of BNSS. By filing the instant application, the revisionist has prayed for washing off entire proceeding as arises out of Sitolkuchi PS case number 33 of 2025 under sections 137 within bracket 2/140 within bracket 3/351(3) and /35 BNS. এগুলো দেখে নেব। দেখা যাচ্ছে
Question number 8.
One senior advocate, Mr. Omnifer, appealing much.
Am I audible, my lord?
Yes, sir.
I'm sorry, I could not come as the principal bench. But here, my lord, I filed this application for quashing of the inter-criminal proceedings at the stage of charge sheet, because earlier I moved a application for quashing of the affair. Since the charge sheet was filed, that was dismissed on merit. No, and now I have challenged one. If you also kindly come to page 22 for a moment of the petition. You also can allow me to file a supplementary affidavit. My junior is there. There's some documents, unnecessary documents. They have not. If you kindly come to page 22, the charge sheet. So you can see the charge sheet was given under section 406, 420, 506, and 34 of the Indian Penal Code. Now you also can come to the page 23, the serial number 17. The brief fact of the case is, my lord, in brief, is over the written complaint Sri Tapos Mojumdar, such and such, to the effect that complainant and one Dr. Otulona Rai, the petitioner, was the business partner of North Bengal Dental Solution. Last few days, the complainant came to know that his partner, namely Otulona, cheated him by not giving the percentage which he deserved. So, Mala is a partnership business. Now, I just place the background of the case. The petitioner is a dentist. I'll place my
Give me a second. Yes.
It's a dispute relating to settlement or accounts of a partnership business. This is under section, under section 48 of the Partnership Act. This is a dispute. And now I just place the first one, I place the partnership deed. If you also kindly come to page, this is a page starts from page 10 of the petition. If you also can come to page 10. A partnership, I am the dentist. It's an admitted fact. And the opposite party number 2 has a medical shop. We have entered in a partnership deed and for running a dental clinic in a portion of the medical shop of the opposite party number 2. These clauses are very, my party, you also can come to page 13, clause 4. That the establishment, you see the supplementary.
Give me a second, sir. Very good, serve notice.
Yes, my lord, can you stay, my lord?
Stop. The supplementary evidence filed on behalf of the revisionist is taken up record on record. Stop. This is an application under section 528 of BNSS. Stop. On perusal of the entire materials as placed before this court, and after hearing the learned advocate for the revisionist, this court is of considered view that the present revisionist is successful in making out a case for
I could not listen, my lord. I have closed. My lord, I stopped. Your lordship, I stopped the copy, my lord. Number 8, my lord.
Yes, sir.
I could not hear because I've been closed, my lord, so I could not hear.
Take instruction from your junior. He will brief you. Yes.
Yes, my sorry.
But the
Sorry?
difficulties is that but warranties issued, my lord, or difficulties is that before more than 1 year, my lord. 7 February 2024 warrant has issued, my lord. But the present status, my lord, that should be ascertained, my lord. There is maybe proclamation or not, maybe, my lord.
No, I cannot understand. What is your submission, Mr. Poddar?
I have earlier on bail, warrant was issued
Huh.
for not taking step, Madam.
Huh.
And I want to surrender warrant bail or make a same bail bond. This is my submission.
What's your good name?
Four,
Four accused person.
four,
Pankaj Topon.
Onaka Tapos.
Their name are not appearing in the certified copy of the impugned order. Which one?
Last.
last.
Certified copy? Huh?
Onaka.
Pankaj. Shambhu is there. Shambhu, Bablu, Nirmal, Puritosh,
Mukul
Mukul, Subhas Barman.
আর বিশ্ব
Huh?
Onaka, Pankaj, Tapos, মানে later part, no steps taken. No steps taken part.
Accused Shambhu Barman, এত. You are present.
No steps taken. First paragraph, accused name, 9 accused name appearing. Next part, no steps taken against the accused person. For first name appearing. Or the name appearing.
So this date was used for appearance, my lord. The accused person will didn't appear before the trial. That is
on
the-
7 February 2024 order, my lord.
Last with the aforementioned observation ওটা একদম লাস্টে গিয়ে দিই এই দুটো যে প্যারাগ্রাফ অ্যাড করলাম এটা মাঝখানে দিয়ে দিই। Yes.
10 my lord, and for this petition.
And for the de facto, my lord.
My lord, this proceeding is predominantly of a civil nature. My lord, the facts are that in the year 2012, the de facto and my lord, this petitioner entered into an agreement of sale for the de facto's parcel of land. Subsequently, my lord, the de facto complainant retracted from that, which ultimately resulted in an arbitration proceeding instituted at the behest of this petitioner. So, my lord, essentially it is of a civil nature. What the de facto is saying is that this agreement of sale on which I am banking my arbitration proceeding as well as my section 11 was never executed by him. That was his allegation at the first instance. However, after we have instituted the arbitration proceeding and he has appeared in that, he
You are the proposed seller.
no, I'm the proposed purchaser. The de facto's
Is the proposed seller.
Yes, yes. He is the proposed seller. He
There was an agreement for sale.
agreement for sale,
The registered or unregistered agreement.
unregistered,
Unregistered.
unregistered.
And that agreement bears the arbitration clause.
Yes.
Then what happens, sir?
We file a section 11 application because he retracted back after executing the agreement. We file a section 11
He
application.
is not willing to sell.
No, he is not willing to sell and he is retracted back from that position and saying that he never executed that agreement of sale. His signatures were forged in that particular agreement.
Very good.
That is his crux of his allegation. I'm not subsequently the matter has been settled. I'm wanting a leave from your lordship to Lord find a joint grant application so that this matter can be Lord disposed of. It has been settled. My learned
So
brother.
it is not ready today.
It is not ready today, my lord. Kindly grants us 1 day's leave. We'll file it over.
Very good.
Renter to service code.
As per request made at the bar, let the
Lord, with deep embarrassment, my lord, I'm paying for 1 day's accommodation. Lord,
not today.
Lord, 11 and 12, both my lord, same matter, same petitioner.
11, 12, not today.
My lord, 11 and 12, my lord, I beg to appear for the opposite party, my lord. My lord, if they could serve me in the meantime, my lord.
Motion stage, my lord, appearing for the first time.
My lord, this
These are very sharp. What is the difficulty?
Wait, I'll do that.
I am appearing in item number 13. You see, I beg my lord's pardon, I was not able to appear physically there. My lords, this case is for quashing of the FIR and along with all the consequential proceedings beyond that. My lords, in the present case, as per the version stated in the FIR, the complainant, namely ex-daughter of so-and-so, has alleged that on the morning of 12th Feb 2025, at around 8 a.m., she went to take a bath in a bathroom situated near the boundary of her house, not inside her house, my lord. This thing is a bit important in this case. She claims that when she entered the bathroom, a man was already hidden inside who allegedly caught her hand and pressed her mouth. And when she attempted to scream, the said person allegedly pushed her and ran away from the spot. She further alleged that after the incident, the news spread among the local residents, and with the help, the accused was identified as one Vishal Shukla, who is the present petitioner in this case, my lords. My lords, the petitioner was working as a driver in a transport company. His primary duty was to take trucks from place A to place B. On that particular he was assigned a duty to take the truck from Jalpaiguri to Lucknow, my lords. So during that stay, my lords, he had to stay in Jalpaiguri for 10 days because of the passing of vehicle by the transport department. That particular thing took at least 10 days, my lords. And because of which he stayed in a warehouse that was immediately situated near the Bhavesh petrol pump. My lords, that is a warehouse where these truck drivers used to stay all the time. Whenever they come there, the truck is loading and unloading. During that period, Milos, they used to stay at that particular place. And Milos, nearby to that warehouse, there is a vicinity where the complainant belongs. Milos, during the entire stay of 10 days, it was the first time, as alleged, if we believe it to be true, it was the first time that the complainant and the accused face off each other. He had no background of knowing each other, my lords. There is a bathroom situated in the warehouse that all of the person using living in that warehouse truckers and the people of the vicinity also uses that bathroom, my lords. And I have been implicated in section 324 of subclause 4, my lords. My lords, reading that I am being implicated in a manner that I went to the complainant's house and then I tried to do bad things with her. And in fact, my lords, it was a public washroom. No hue and cry was there. And then, my lord, section 126 wrongful restraint. My lords, it is
Wherefore I will get that it is a public washroom.
please, my lords, I am unable.
What prima facie materials have been placed that
Please, my
where the accused was hiding, was a
Please, my
public
lord.
washroom. Wherefrom I'll get that?
My lords, because that is basically a warehouse and there is a public washroom. And that warehouse is completely covered under the CCTV. My lords, for if the police is directed, if the prosecution is directed to get the CCTV of that vicinity, that warehouse, my lords, it will be clearly seen that the trucker used to go there, sleep in their truck, and use that bathroom, that washroom, my lords. The complainant lives in a nearby vicinity. My lords, it is just a case of falsely implicating the outsiders, my lords.
The FIR says, the written complaint says that the bathroom is situated within the boundary of our premises.
That is completely false statement, my
So
lords.
what prima facie material is there to take a contrary view in order to invoke the power of under section 528?
My lords, if we read line by line, the FIR says that on Feb 12th of, my lords, I am reading the translated version.
Yes,
On
sir.
12th of Feb 8:30, I went to take bath in the bathroom near the boundary of my house. There was already a person, my lords, near the boundary, not inside the house. Section 324.
No, not near the boundary. Within the boundary. You are a Bengali?
My lords, I am outsider. I have a translated copy of. I live in Chandigarh.
That is the
my lords.
difficulty.
My lords,
You understand Bengali?
My lords, I'm not well versed.
A wrong translation has been given. A preposition has been given. A wrong preposition has been used in your translated copy. It has been stated that within the boundary of my premises.
My lords, if let's assume
a prima facie case of trespass has been made out.
My lords, let's
Just
assume
show any contrary material that that washroom is situated outside the vicinity of the premises in question, and that is a public washroom.
Please, my lords. Let's assume for a moment, my lords, if she is saying that inside her vicinity, my lords, the vicinity of her house.
Inside the boundary, sir, inside the boundary of our premises. It shows it is a private washroom. Why you have entered into another bathroom? Other person's bathroom?
I am not entered into that bathroom. I use the bathroom which is inside the warehouse. As per the allegation.
Sir, I intend to see the prima facie material that to do the affidavit.
My lords, the notice of motion be issued and state be directed to kindly produce the material.
That bathroom which I use, that the CCTV camera is already.
So this is an application. This is an application under section 528 of BNSS, whereby and whereunder
I'm for the state, my lord.
14, I'm for the petitions. Lord, this proceeding is very peculiar in nature. I must firstly submit. Lord, takes up page 14 once, that is the written complaint.
It is also 528,
Yes,
quashing.
what is the charge?
Page number, sir?
Page 14, my lord, is the written complaint, 1/4. Well, the complaint lodged by one Meena Kumari, kindly reads it once.
Yes.
The first discrepancy is in the FIR itself, because at page 15, the schedule of the land, she does not say which land. She only says all that pigeon parcel of the land in Moja of dark number 391, as if everything belongs to her. Now, my lord, I'll take your lordship to the charge sheet. Now, all these persons, whose names are mentioned in the paragraph 2, as well as the bail out of Shiv Mandir, are implicated. Ultimately, my lord, the charge sheet is fine. Takes up the charge sheet at page 16, my lord, 16. One of the most, my lord, laughable charges that I've come across. My lord, page 17 is the relevant para. Page 17, last paragraph onwards. Further investigation, it is crystal clear that the accused person, Rahul
You are reading which portion, sir?
My lord, page 17, last paragraph.
It starts with?
Further investigation, last paragraph. Page 17, my lord.
I am on page 17. First paragraph is during investigation. Thereafter, I consulted with my superiors. That page.
My lord, then the pagination is little incorrect, my lord. Takes up page 16 then. We have a
Yes.
discrepancy of one.
Further investigation at page number 16, sir.
So further investigation, it says it is crystal clear that the accused persons Rahul Tamang, Rajan Sharma, Gopal Bhagat, and Etua Bhagat is also involved in transferring a piece of land at Moja Champashari under Pradhan Nagar PS in the name of Manu Tamang, which complainant's father is the actual owner by means of a forged and fabricated document. It says this, but my lord, there is no forged or fabricated document on record. No document says, my lord. But he says that these persons are involved in transferring a piece of land. Now, my lord, takes up thereafter, page 18. Page 17, my lord. Page 17 kindly takes up the paragraph from hence I submitted charge sheet. So, my lord, he submits charge sheet against these 4 persons. Rahul Tamang, Rajan Sharma, Gopal Bhagat, and Etua Bhagat. On the basis of nothing, first. But he absolves all the other persons. He, my lord, says under 447, 427, 467 did not establish against the following persons and may kindly discharge them from this case. Now, my lord, the first person himself is very important because the first person, Rajan Taman, is the father of the present petitioner. Now, my lord, the investigating officer absolves the father of the petitioner on the basis of a particular title deed.
No, will you place that paragraph, sir?
Yes, which one? No?
Hence, I submitted.
Yes, my lord. Page 17.
Kindly place that.
Hence, I submitted charge sheet against accused Rahul Tamang, Rajan Sharma, Gopal Bhagat, Etua Bhagat, White Pradhan Nagar PS charge number 115/2025, dated 14/3/2025, under sections 447, 427, 467, 468, and 120B, as well as Pradhan Nagar PS 430 of 24 under 447, 427, 467, 468, 120B for their trial in open court of law. under section 427, 467, 468, 120p did not establish against the following persons and may kindly discharge them from this case. So, my lord, 4 persons are implicated, but the rest are let off. Now, my lord, the rest are, why are they let off is important. It is because why they have been let off, which is why I should also have been let off. I'll show that to your lordship.
Give me a second.
Yes.
আইপিসিটা বার করুন তো,
Lord, I have the answer.
একদম তলার বইটা বার করুন।
How a case of forgery has been made out?
Nothing. Exactly my point. Because here the principal issues of forgery. She says that her grandfather's land has been sold off by some persons. Now, what is that document? What is that forged document? Why is that forged document? That question has, my lord, no answer. Now, my lord, I'll show your lordship what has actually happened. Now, my lord has seen Rajan Tamang's name, the first person who has been let off. At page 17, my lord.
Rajan Tamang is the
Father of the
FIR name person.
Yes, he was implicated in the FIR, but ultimately let off in the charge sheet.
As Raj Tamang.
No, my lord, Rajan Tamang. His name in the FIR, my lord will find in the last paragraph.
Yes, Rajan Tamang is there.
Yes.
Son of Rangolal.
Rangolal Tamang. Yes. This person is very important. This is where the source of the dispute arises. Now, this person actually is the owner of the plot of land in this particular LR plot. My lord, takes up page 19 once. Page 18 once. Page 18, my lord, is the certified copy of a deed. And my lord takes up the next page thereafter. My lord will
Page number?
Page 18.
Huh?
18. 1.
18 to 8 and 19.
Page 18 is the certified copy.
Certified copy of what?
Of a deed. Of a deed of the father of Rajan Tamang. Rangolal Tamang. My lord has just noted that name. Rangolal Tamang.
এই উকিলকে তো আমি তো কিছু পেজ খুঁজে পাচ্ছি না ও।
Annexure C, page 19, you have stated certain.
How do you file? I don't know.
Lord, this I humbly apologize. This is so that
Page 19. Annexure C.
Lord, page 19.
Pretty much.
But previously there was a confusion, the pagination is right. Pagination. Page 19, my lord. This is the certified copy of the deed number 2017 of 1961. Takes up the next page, my lord, page 20. Kindly reads this horizontally. My lord will find the name of Ronglal Tamang in the third line. Ronglal Tamang bought this particular plot of land. Let us found the name.
Yes. So why don't you provide a type copy, sir?
Yes, my lord, because of urgency, we had filed this.
You could have come with a type copy later on.
Yes,
Rangolal Tamang is a seller or is a buyer?
he is the buyer. He's
He's a Grohita.
Yes, he's the Grohita.
Therefore, I will get that. It's very difficult to read the handwriting of those deed writers. কৃষি জমির দখলি সত্ত্ব বিশিষ্ট জমির পরিমাণ 100, জমির মূল্য মৌজা সাচানসাদ বরাবর শ্রী রঙ্গলাল তামাং পিতা সাচানসাদ কৃষিকার্য সাকিম সাচানসাদ থানা শিলিগুড়ি।
My lord takes up, my lord.
So who is the seller, who is the buyer? Very difficult to understand.
The seller's signature, my lord, are horizontally at the top. Those are the sellers. Upendra Narayan Rai, Nipendranath Rai, Moholal Rai, and Shoholal Rai. These four are the sellers, which is why they executed the deed.
It is a deed of registered deed of
Conveyance.
executed on 16.
17/4/61.
Seventeen 461.
Yes.
And where is the schedule?
Schedule, my lord. At that point, my lord, there was no schedule. That plot of land is, my lord, 3 acres. My lord will find at the first page itself.
Sorry?
The plot of land is, my lord, 3 acres. Page 20. The first line, my lord, 3 acres.
3 একর জমির মূল্য 1700 টাকা মৌজা
Yes.
চম্পাসারি under which plot?
My lord, plot at that point was, my lord will find at page.
Oh, it's very difficult. Provide a type copy. It is very difficult.
No, page 21. Kindly once.
What is this?
All the plot numbers are provided, my lord. Tag number. These are all the RS plots of 1961. 158.
Which line?
Lord, fourth line on.
Dag number 158.
Yes, firstly 158. Thereafter 206. Yes, these are the two plot numbers. In 158, 2 acres were sold off, and my lord, in 206, 1 acre. My lord takes up page 22 thereafter. Next page. My lord will find at the top the Shavik Dag number is 206. Shavik Dag number is 206. We are concerned with this particular plot. My lord will find the name of Rajan Tamang, Pita Rangolal Tamang. Thereafter, my lord, page 23. Again, my lord will find at the top Shavik Dag 206. And my lord, the name of Rajan Tamang, the third entry. Rajan Tamang, Pita Rangolal Tamang. So this is essentially the dispute. Rajan Tamang is the Rayat of that particular plot of land. The petitioner number 1 before you is the son of Rajan Tamang. Now Rajan Tamang has been let off on the basis of his purchase. And
Rajan Tamang has been
let off. He has been absolved. He has been discharged from the case in the charge sheet.
Huh.
He has been discharged. I am the son of Rajan Tamar. My claim over that plot of land arises from his title. I was under his aegis, which is why I went to that plot of land. His plot of land. I have been implicated under sections of
Rajan
forgery.
Tamang is still alive.
Yes, he's still alive.
You are the son of Rajan Tamang.
I am son of Rajan. The
In
petition-
that capacity, you went to that property.
Yes. It is as simple as that. Now, my lord, the second petitioner is also important. The second.
Rahul Tamang is the son of Rajan Tamang.
Yes.
And who is the second petitioner then?
Rajan Sharma is the RO, is the revenue officer of that particular BLR. Now, my lord, the BLRO has also been observed in the charge sheet, but the RO has been implicated.
Revenue inspector.
He is the local revenue officer.
Revenue officer.
Yes. He is the local revenue officer. He has been implicated with no basis at all, but the BLRO has been observed.
Now, how, according to you, how the case of forgery has been made out?
Nothing.
Yes.
That is exactly
Yes,
my
sir.
case. What is the forged document? These are rival titles.
After completion, my lord, I will start.
Very good, sir. Yes, sir.
Lordships, in this case, Lordships, case study is very much required. As because your Lordships, case study is not called by us as because
It is with you.
no, case study is not with me.
Oh.
Otherwise, Lordship, it will be very difficult to ascertain and moreover, maybe
Serials are there in the charge sheet itself.
maybe
Serials
the
are-
others may be discharged from the charge sheet, but
What is that?
this is their copy only, your Lordships.
Oh, I see, I see, I see.
Just
it-
one day accommodation,
It
Lordship.
is in motion stage.
Yes, motion.
I needed just one day accommodations as because I just want to know
Let there be a statement
involvement of the
proceedings. We have
petitioners.
We have
On
been granted
perusal of
activity.
oh sorry, this is an application.
Lord, I am for the petitioner. Lord, this is made with your lordship. It's an application for quashing of charge sheet. Lord, the offences are under section 363, 365 of the IPC, read with Lord section 6 and 17 of the POCSO Act. Lord, at the outset, I would say, Lord, that anticipatory bail prayers of this petitioner, Lord, was dismissed, was not allowed by the Honorable Division Bench of this court. Lord, subsequently, the first application, Lord, considering the gravity of the offence, Lord, it was dismissed. Lord, I preferred a second application for anticipatory bail. Lord, on the instructions of my client, that there was a consensual relationship between the principal accused and the victim lady. And Lord, even they had gone for marriage. But considering the age of the victim girl, which was 17 at the relevant time, Lord, the Kaji declined to register the marriage. Lord, on this premise, I went before the Honorable Division Bench, filing a second anticipatory bail application. Lord, I had requested the bench to call for a report from the police station and from the Kaji concerned that whether this incident had happened or not. Lord, that report was submitted before this Honorable Court. Lord, the report says indeed that yes, they had come for marriage. They were in a relationship, they had come for marriage, but since the victim girl was minor at that relevant juncture, Lord, the marriage could not be registered. Lord, but however, the Honorable Division Bench declined to grant me any relief on the ground that since no new material has been brought on record, and Lord, my prayer for anticipatory bail was declined. Now, Lord, I have come before this Honorable Court for quashing of the Lord, on the premise that Lord, before this Honorable Court, Lord, the investigating agency itself has filed a report saying that they had gone for marriage. Now, Lord, once the accused person and the victim girl, along with their family members, Lord, if they goes for registering their marriage, Lord, it prima facie satisfies that they were in a consensual relationship. So, Lord, the allegation of forceful intercourse or rape, Lord, does not stand in the facts of the present. Lord, I'll take your lordship to the
Marriage absolved the offense.
No.
Though no marriage has been taken place.
No, marriage has not been taken. Lord, my premise is that Lord, they were in a relationship. So it cannot be said, Lord, that there
So
was
relationship absolves the even if I accept it and your face value,
Lordship.
the relationship absolves the offense.
Lord, relationship does not absolve the offense, but relationship prima facie says that there was no forceful or non-consensual sex.
Even if there is a consensual sex, then offense absolves.
Lord, considering the age of the victim girl, Lord, the age of the principal accused, and Lord, their past relationship, Lord, it cannot be, Lord, there are plenary of judgments, Lord, passed by the Honorable Supreme Court. Lordship knows better than me, Lord, that in case of consensuality between the victim girl and the accused person, Lord, the offense of rape cannot stand. Lord, this is not a case, Lord, where a 50-year-old man, Lord, ravishes a girl of 10 years, 12 years, or 15 years. Lord, considering that, how it happened further, Lord, since the Kaji has declined to Lord, register the marriage, Lord, thereafter this case was started.
Constitution Marco.
Lord, I'll take your lordship.
Constitution.
Lord, to the report.
Have you brought the Ganan, everything Ganan? Yes.
Lord, come to page 31. Lord, that is the report filed by the investigating agency. Lord, the second para. It says in this regard, I, SI so and so of so and so PS had been to the house of Kaji situated at village so and so under Jalpaiguri PS, which is Jalpaiguri, and consulted with the Kaji Sahib. He revealed that the petitioner Lahabul Alam and the VG had visited him for marriage registry, but due to minor age, the Kaji Sahib refused to entertain them. A written declaration has been collected from Kaji Sahib, MD so and so, which is enclosed with this report. Annexure 1, written declaration of Kaji. Now, the next page is the written declaration of the
What is the written complaint, sir?
written complaint. Page 33, Miller. না না এটা না 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 না
আরে ছোট বই নেই, ছোট বই আনতে বলুন, বেয়ার অ্যাক্ট। থাক থাক থাক, নিয়ে আসতে বলুন বেয়ার অ্যাক্ট।
Lord, I'm sorry, Lord, the written complaint has not been annexed, the charge sheet has been annexed.
Page number 33 is not the written complaint.
That is the written complaint preferred by my relatives, Lord, against the victim girl's family.
Then without written complaint, how can I do?
Lord,
On perusal of the charge sheet, how can I work?
Lord, may I come back tomorrow with the written complaint? Lord, inadvertently, my Lord, not annexed.
এই উকিল ওকে এটা দেখান। আমার বুদ্ধি তো এটাকে রিটেন কমপ্লেন বলে, তারপর জানি না উকিল ওকে কি বললেন। এত মামলা পড়ার সময় নেই।
Yes, Lord. Lord, this is certified copy, madam, sorry.
Is not there to written complaint?
Oh, no, Lord, I have, Lord. It is actually not certified copy, not paginated, so page number was not there. I'm sorry, Lord.
So on perusal of the FIR, prima facie no cognizable offence has been disclosed.
My Lord.
Then
My Lord, why I'm saying, because they say that the daughter, my Lord, the victim girl was, my Lord, was forcefully ravished on the premise that she will get married with the main principal accused will get married with the victim girl. And my Lord, it indeed, my Lord, the fact is that they have gone for marriage. My Lord, we'll see from the fifth line, sixth line from the bottom. Eighth line from the bottom. So, my Lord, that was the case.
so what was the case? Very difficult to understand.
My Lord, the case is that they
No cognizable offence has been made out.
My Lord, they say that on the premise of marriage, the victim girl was ravished. So, my Lord, this fact, my Lord, even if we consider it as true, even if we consider the allegations to be true,
So face the trial. This court has no power under Article 142.
my Lord, we consider one thing, the aspect of mainstream.
Lord, the element of mens rea is totally absent in the facts of the present case. Lord, why I am saying, Lord, the complaint was lodged itself on the premise that there was the consensual intercourse was on the premise.
Sir, even if I accept it as a face value, does it absolve you from the offense?
Lord, if there is no mens rea, Lord, the criminality is not there. Lord, the criminality, if there is criminality, definitely, Lord, the offense stands, Lord, I have to face trial. But, Lord, if prima facie it comes before this court that there is no mens rea, Lord, how can, Lord, then I am being.
Show me the relevant provisions of the POCSO Act.
Lord, the from.
The admission is not a matter of course, you have to satisfy.
Lord, that is. Lord, from section 6.
Take down. Mr. Client at present dismissed at the stage of admission. Dismissed at the stage of its admission. Now to file টা নিচে দিয়ে। But is there a CRAN?
No, Lordship. There was a CRAN earlier,
It was been disposed of.
Lordship. The case of promiscuity. Lordship kindly goes to page 13.
Is it a quashing petition?
Possibly. Page 13 is the written complaint lodged by this.
Which for the state?
Both are major, Lordship. The petitioner herself lodged this complaint where she admitted
Yes, Mr. Ganguly.
Lordship.
Very bad case.
Lordship. Lordship says that the written complaint where the allegation is sexual intercourse on the promise to marry.
Apart
Now-
from that, no other material is there.
Lordship, there are materials in my favor. I'm showing that. And I'm backed by several judgments of Honorable Appeals Court on this very point.
Yes.
Lordship, kindly says page 18 then. Now, PO is point number 21, kindly says, Lordship. PO is one resort at Mendavadi. Page 21. As per the narration of the victim and as per FIR also, PO is a resort at a place called Mendavadi.
You are referring page number 17 or 18, sir?
18, Lord. Medical examination of the VG.
Yes.
First page, point number 21, paragraph 21. Place where it committed one resort at Mendavadi. What is, Lordship? Last line.
Page number 17.
18, Lordship.
No, you just referred page number 17.
17 is the forwarding, Lordship. 18 is the medical.
Yes, I'm sorry.
Our page 50.
No, it's all right. Sir, it's my mistake.
Last paragraph, Lordship. One resort at Mendavadi.
Place where it is committed.
Lordship. Kindly notes down this this place. One resort in Mendavadi, which we have also found in page 13. That is Mendavadi resort in Ejai. That the FIR written complaint.
Yes.
Mendavadi. Now, from the four corners of the record, Lordship will not find that she has identified the name of the resort or the police had made any endeavor to find out the PO and examine the available witnesses and.
Mr. Ganguly,
I'm
those are
coming,
case of
Lordship.
evidence,
I'm
sir.
coming. I'm
Those
coming.
are case of evidence.
I'm coming, Lordship. I'm coming. I'm coming. Lordship, next page, page 19, Lordship will find. That the
Yes.
doctor found the hymen old ruptured. Old ruptured. Now kindly see the date when the.
Mr. Ganguly, law is very settled that in the event the material which are placed is in its face value, it does not constitute an offense. You have to satisfy that in.
Lordship, I'm coming to that. From the FIR, Lordship will find that the act of.
Mr. Ganguly, I am quoting a Supreme Court judgment.
Lordship.
Where the allegations made in the first information report or the complaint even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the act.
Jalpaiguri is clear on that. Whatever is the Niharika infrastructure also.
Then-
I am coming, Lordship, from the FIR, if Lordship sees these alleged sexual intercourse on the promise to marry, does it constitute an offense? The Supreme Court says, even in the India 2025, no. I'm coming to that. Not only that, Lordship, when he sees this certified copy, the potency test of the accused, this is the opinion of the doctor.
Capable.
Nothing to suggest that he is capable.
Only 376 হলে কত 417 আছে
I'm coming to that. Supreme Court judgment, second number 17 আছে। The act of sexual intercourse, as per my is a mental act, not only physical, Lordship.
The definition of 376 is now changed.
Lordship.
Even touch is also a
Lordship,
Then-
Lordship, but that thing has to come. Now, Lordship,
Mr. Ganguly, don't waste your time. It's not a good case for you.
Lordship, may I place a judgment in some.
No.
This is the judgment of 2025.
Show me the relevant place.
Lordship. Kunal Chatterjee, this SLP was preferred from an order of our High Court.
Yes.
Kindly close to this was a minor. The VG was 15 years. Even then, what did the Supreme Court says? Kindly see, Lordship. Page 2, from page 2, may I read, Lordship?
Yes, sir.
We have heard the last paragraph. We have heard learned counsel for the parties at length. Learned counsel appearing from the state has relied upon definition of rape and would argue that the consent given by the minor is no consent and it would still be a rape. In our considered opinion, as regarding the rape being committed by the appellant when the prosecuting was minor, there is absolutely no evidence and definitely no forensic evidence with the prosecution. It is only an allegation in the FIR after 3 years in order to make out a case under the POCSO Act. That such an act of rape was committed 3 years back when she was a minor. She was also categorically stated that she consented to the act as there is a promise of marriage by the appellant. This court has held in several decisions, this is important, Lordship, that promise to marry and subsequent physical relationship between the two with consent would not amount to rape, and the reasons therein have been assigned in such and such. All the decisions of Supreme Courts have been considered. Under the present facts and circumstances of the case and the nature of evidence with the prosecution, particularly the long delay such and such, it was quashed. I am banking upon another judgment, Lordship, regarding promise to marry.
Here, the allegation is first rape, then promise to
Kindly
marry.
seize the 164 statement. Kindly seize.
Let me see.
Kindly
Yes,
see the 164
Mr. Chakraborty. What
My
are
lord.
there?
Lordship, my certificate copy is there.
Also,
The
my lord.
164 is also there.
my lord, medical page 15, my lord. And 164, my lord.
Page 15.
15 is medical, my lord. Hymen ruptured. 164 of the victim, my lord. Page 30.
লাল কালকে চেঞ্জ করে দাও তো ভাই।
The certificate copy, I just sent it.
লাল কালকে পড়ছে মনে হচ্ছে।
Capability test also done, my lord.
দেখি দাও দাও।
Yes, certificate. Madam, may I get back my certificate copy so that just now.
You will get back everything,
Got it,
sir.
got it.
Wait. Page number 15, what does it say?
My lord, it is a medical report, my lord. Hymen is ruptured.
Lordship, page 18 of my petition, same thing.
Yes.
And my lord, then my lord, kindly appreciate page 32, my lord. This is a 164 statement of the victim, my lord.
Kindly see, Lordship, whether it will.
Page number?
32.
He says he promised to marry first and then to put close.
Yes. Next.
417 is there, my lord. Section 417 is there. That is corroborating
417,
of IPC.
cheating.
Dhoka. Victim is 22 years old and the present petitioner is 27. Other 161 statement, that is highly corroborating, my lord.
Take down.
আমার একটু সিটিটা দিও না গো। হ্যাঁ ওইটাই, কেস ডায়েরিটা। থ্যাংক ইউ। Great.
Item number 18.
18 madam. I have been for the state madam. 10th of July 2024. Filed. Ma'am.
কি বলছেন? হ্যাঁ? Who is for the petitioner?
Madam, petitioner is the Devodit Kundu.
No, who is Mr. Ganguly then?
That is next.
Malat, item number 19, I am Malat.
Item
number
19.
90.
Item 19.
No, we are on 18, sir.
Malat.
Several dates were passed, my lord, but they did not turn up. The petitioner did not turn up. 490 to 34. And read section 3 and 4 Dowry Prohibition Act.
Materials are there. CD, it is CD.
Though the case diary is not available, but the.
No, it is available with me, sir.
Oh, it has been taken.
Charge sheet has been submitted under which section, sir? Oh, you have your note 498A, 34
and 34.
Asun.
34 of the Dowry Prohibition Act.
None appears on behalf of the petitioner.
Actually, my lord knows the consequence of in the section of billing section, my lord. That is why, my lord. Sorry, my
Very
lord.
good, sir. No, nothing to be sorry.
One.
One কি হলো? One at 1 p.m. One at 1 p.m.
Oh, ask.
Why it is to be mentioned? Oh, at that time the CRAN was not available. Oh, CRAN is a can. What modification you want, sir?
Can application NHR B page 39.
In the earlier order, the direction was given to the respondent number 6. Instead of respondent number 6, it should be
Page number 39. Which is one is the relevant page? Respondent number 6. The respondent number 6 shall treat the instant date of the presentation. The representation was made with the respondent number 6 authority or not? Where is your representation?
Page 37.
No, in the main read petition.
Petition lordship, page 36 lordship, annexure 5. In can application lordship.
Come to the main read petition.
In the petition lordship, page 28.
Page 28. To the Secretary of the West Bengal Board of Secondary Education.
Lordship.
Secretary is the to the Secretary. Here is it is respondent number 4. কি যে বলছেন ওগুলো আমি তো বুঝে উঠতে পারছি না। Respondent number 3, if you want to substitute respondent number 6 to 3,
3 and 4 lordship, West Bengal Board of Primary Education, secretary lordship.
then it should be 3 or 4.
3 and 4 lordship. 3 and 4 both lordship.
No. Respondent number 3 is the West Bengal Board of Primary Education.
3 is the body.
And body, and the 4 is the authority.
Yes.
So 6 is to be substituted with the 4 or 3. Who will consider?
4.
4 will consider. আসুন।
my lord, before rising, my lord, item number 19, my lord, may I come back tomorrow, my lord? My lord, 19, my lord.
It will be taken up tomorrow, sir.
But 18 already completed. I have item number 19.
It will be taken up tomorrow, sir.
My lord, my lord, my lord, my lord. I'm getting.
In the first half, I will take up throughout my circuit. I will take up the criminal matters unless I indicate in the cost list. So be rest assured, it will be taken up tomorrow.
Great.
I see.
Yes?
Your Lordship, I'm apologizing beforehand, but on a compelling circumstances, I'm mentioning a matter if I'm permitted to mention, Your Lordship.
What is the urgency, madam?
Urgency, actually, Your Lordship, I missed my time in the morning, Your Lordship. That's why I'm
That
mentioning.
cannot be urgency.
Your Lordship, in this matter, the mediation was granted and till date, no mediation was ever been, and there was a.
Mention tomorrow, I shall consider.
Your-
Mention is taken in my court
Your
at
Lordship,
the first sitting.
Your Lordship. I'm grateful and I apologize, Your Lordship.
It's all right.
Actually, the appeal has been filed within time, Lordship, so formal direction is possible.
Which order is impugned?
The order dated 36/2025.
Oh, it is the MSCC appeal. I see, I see, I see. Must-
Section 5 application, Lordship. So, kindly.
Item number?
37, Lordship. Kindly keep it in the next week, Lordship.
It is submitted on behalf of the appellant. That Same order like 37,
36.
36. Only one respondent. Only one respondent.
No.
এদিকে ফাইলটা দাও, ফাইলটা দাও।
Four respondents are there. Different vehicle has also been included. Smart.
So what the respondent number 3 and 4 they have contested. ও তাহলে এখানে হবে রেসপন্ডেন্টস হবে রেসপন্ড নাম্বার 1 to 4 হ্যাঁ?
One contested.
হ্যাঁ?
One and two contested. Actually, same insurance company. Both the vehicles, operating vehicle and victim vehicle, both are covered by the same insurance company.
Who are 3 and 4?
The owners.
They have contested.
They are not contested. They are not, 3 and 4 are not contested.
Kindly check. Opposite party Subol Sutrodar did not contest, so this case is proceeding ex parte opposite number 3. Then what about Swati Singh? What about her? Who is Swati Singh? Huh? In the memo of appeal, I'm sorry, in the judgment, only 3 opposite parties are there. Then where from will get the fourth respondent? I beg your pardon? Then why it is not there in the judgment?
Actually.
ওই তাহলে তুমি ওই এইটা করে দাও ওই অপোজিট পার্টি নাম্বার 4 এর উপরে সার্ভিসটা ডিসপেন্স উইথ করো since the opposite party number 4 since the respondent number 4 did not contest before the learned trial court service upon the respondent
Only two lordship and nothing for the petitioner husband. The order of the learned petition is mentioned that in an application of the wife under section 24 of the Hindu Act. What happened, husband petitioner mother marriage took place in the month of October 2019 and the same was registered under the Hindu Marriage Act. Subsequently, the husband came to know that the wife has a earlier marriage which is subsisting and without any duty for resolution of marriage, in subsistence of the earlier marriage, the wife married the petitioner husband. So, the husband filed an application under section 11 of the Hindu Marriage Act, that is on page number 13 onwards of my petition, for decree on the ground of nullity of this resolution of marriage on the ground of nullity. Because this instead the present marriage with the petitioner husband is it's not legal, it's in subsistence of the earlier marriage and it's a void marriage. Now, lordships, during pendency of this application, the wife filed an application under section 24 of the Hindu Marriage Act. That is page 24 of my petition. I have filed my written objections where the husband categorically stated this marriage is not valid marriage since it has been done in during subsistence of the earlier marriage. So, since the marriage is not a valid marriage, so the petitioner, the wife is not entitled to get the award under section 24 of the Hindu Marriage Act. And now, lordships, the improved order, that is a certified copy of the order. I want to draw your lordships and attentions with regard to the depositions of the OPW2, who is the father of the earlier husband. It's inner page 4 of the certified copy.
Where is your written objection?
Yes, your lordship. Written objection is in page 26 onwards. Lordship, can you see the paragraph number 6?
No, you have annexed the amended plan.
Amended plan, the amended additional written statement, everything I have annexed.
What is the assertion?
With regard to the marriage.
With regard to the nullity of the marriage?
The late lordship.
Yes, sir, madam. That is the basis, no?
Got it. Lordship kindly comes to page 15.
Yes, madam.
3C, paragraph 3C, the middle paragraph. That latter of one of the relations of the petitioner came to the house of the petitioner who, on seeing the respondent, disclosed to the father of the petitioner that he has seen the bride earlier, and he ultimately told the father of the petitioner that the respondent had her earlier marriage with one Susanto Bormon, son of Virendra Bormon of village Patha, P.S. Shitai, district Kuchbihar, and to become sure, the father of the petitioner had been to the village of Dhumer Patha and contacted with the said Sushanta Bormon, with whom the respondent entered into her earlier marriage. That on the request of the father of the petitioner, the said Sushanta Bormon and his father Viren Bormon handed over certain photographs.
Very good. Those photographs have been exhibited in
The good order.
internal page number, madam.
Number 2, last paragraph. In order to prove the
Give me a second.
Yes.
Yes, ma'am.
In order to prove the case, the petitioner Priyanka Roy Bormon has petitioner means the wife, lordship here, has examined only herself as PW1 has produced her Aadhaar card exhibit. On the other hand, OP Sanjay Bormon, the husband, while trying to disprove the case of the petitioner, has examined himself as OPW1, one Viren Bormon as OP2, one Deepak Das OPW3, and has produced 4 photographs as Exhibit A series, one compact disc as MAT Exhibit 1, one flash drive Exhibit 2, some photographs along with certificate under Section 65 of the Indian Evidence Act, Exhibit B series, and one marriage invitation card as Exhibit C. Now,
Yes.
this kindly comes to inner page 4. The depositions of the father of the earlier husband.
Take down.
43, my lord, I appeal. One of the defendants, particularly defendant number 3 in a suit for partition, separate possession, declaration, injunction, and other resistance.
Defendant is the petitioner before this court.
Defendant number 3.
Defendant number 3, Subroto Pal is the defendant number 3.
Yes.
Which order is under challenge, sir?
My lord,
Order number 71.
yes.
Give me a second. So what is the wrong in the order?
And the plain manner. It has been specifically stated that I am stranger, and it comes to the plaint is at page 18. And I'll take your lordship to the relevant paragraph at page 16, which is at paragraph 16 at page 26. What is there? I'm placing it. That the suit land still owns and possessing jointly by the plaintiffs and defendant number 1. And same are were not partitioned in any way by and between the plaintiffs and the defendant number 1 herein. The rest defendants, being defendant numbers 2 to 7, are mere strangers in respect of the suit, and they have no right, title, interest over the suit land. So I'm a stranger, my lord. I'm a stranger. It is the plain case that the plaintiff and the defendant number 1 are the joint owners. So if at all any relief has to be prayed against.
Then who are you?
I am claiming title to defendant number, but a total stranger. Kindly cease. According to them, my lord, according to the plain case, my lord, we are occupying illegally. It is at page 20, paragraph 25. He comes to paragraph 25 at page 28. My lord is there. It is stated as place that the cause of action of this suit arose firstly on last part of month of September 2014, when the plaintiff jointly requested to the defendant number one that the suit land should be required to be partitioned according to law. Subsequently, on 12/11/2014, when the plaintiff asked the attorney to go to the suit lands and also asked.
Read paragraph 21 first.
Paragraph 21. Then the plaintiff could learn that the defendant 2 and 3 jointly trying to sell out suit land with the help of.
No, sir, I'm sorry. Read paragraph 18 first.
18. That the defendant number one, in collusion with other defendants and some land brokers of the locality have created a panic and fearful environment so that the plaintiffs have to give up the lawful claim of the partition or the suit land. The plaintiff represents the defendant number one with the help of other defendants who are mere strangers in respect of the state land at the moment transfer the suit land by changing the nature and character of the same. So if at all.
Then, sir, read paragraph 21.
21. The plaintiffs come to learn the defendant number 2 and 3 jointly trying to sell the suit lands with the help of the defendant number 1, and for that end, in view of they are searching for prospective buyers concerning the.
Then what is the prayer?
The prayer.
Preliminary degree of partition?
Yes.
Very good. You are not a necessary party. I admit. A degree declaring such and such.
No right title.
Very good. Then what you have got to say with regard to prayer 3 and prayer 4?
A decree declaring that defendant numbers 2 to 7 have no right title and interest over the suit land mentioned in the schedule below. Decree restraining the defendants by an order of injunction. This file could have been very well played in a separate suit.
Why? That will lead to a multiplicity of suits and proceedings.
Partition cannot.
Sir, suit is not only a simplicity of suit for partition. This suit for partition, declaration as well as for mandatory injunction.
Join the causes here, my lord. It is a suit for partition. They cannot claim against partition. And it is their claim that I am a stranger to the.
So what is the bar?
The stranger, my lord. How can a stranger be made party to a?
If a stranger makes an attempt to cloud the right, title and interest of the plaintiff has no right.
There is no divisible share with the partition.
Not required, sir. Not required. Suppose X and Y are the owners of the joint owners of the property. A, B, C being the strangers have made an attempt to interfere with the peaceful possession of the plaintiff X after in connivance with defendant Y. So there is no cause of action.
Yes, a separate cause of action.
So they will file a separate suit.
Yes, may I conduct tomorrow with the judgment of the.
Not required, sir.
My lord, there is Supreme Court judgment on this.
Absolutely, I'm sure. Very good, sir. I will not grant time.
My lord, unless there is a divisible right, my lord.
I understand. I will record your submission. Listen to my order. The subject matter of the instant revision application
Lordship. This is first one appearing Lordship, that is an application against the order of the district judge. We have filed an appeal against the confiscation proceeding started by the forest official Lordship. The confiscation order is next in case number 17 Lordship. And the
Page number?
Page number 17 Lordship. The entire. First, may I submit?
Yes, sir. Yes, madam.
The confiscation proceeding in this case Lordship completely vitiated the provisions relating to the Forest Act Lordship. First Lordship, there is a three grounds Lordship in this case. First Lordship, for any forest confiscation Lordship.
Against the order of conviction,
Yeah.
misappeal lies.
Yes, Lordship, because so this is my application lies because this.
No, against the order of conviction, you prefer a misappeal.
Yes, Lordship.
That is an appellate order. Show me the law.
Section 52B, any person aggrieved by order of the confiscation may within 30 days of the date of communication to him such order prefer an appeal to the conservator of the forest of the circle who shall, after giving an opportunity on being part of the appellate and the authorized officer pass such order as it may think fit conforming, modify or order of the appeal against the order of the forest of the circle shall be final. The decision of the forest officer shall be final, means they are
Against the officer of the forest officer, who is the appellate authority?
Authorized officer is the appellate authority Lordship. I have one, I think the one more.
এই আমাকে ফরেস্ট একটা আনিয়ে দেওয়ার ব্যবস্থা করুন। Forest actor. Is pass over for some time. Get yourself ready. I'm taking up the second appellate. I'll take up the.
Lordship, the authorized officer is acting.
I'll take up. Let the book come first.
I am for the petition.
আগেরটা ছিল 44 না? 44 পাসওয়ার্ড হলো।
He said application has been filed for the expeditious hearing of the proceeding Lordship. It's
The plaintiff or the defendant?
I am the petitioner husband. I have filed one
Before the learned trial court, you are the petitioner husband.
petitioner
In a matrimonial suit.
in the matrimonial. I have
It is a suit for dissolution of marriage.
nullity, suit
for nullity.
nullity under section 25 surplus 1 of the Special Marriage Act. Since 2022, the marriage the case was been initiated by the
What is the ground? What is the ground?
Lordship, I am being grievance of that this matter has been stuck out in the evidence stage. Since February 2024, the evidence was been commenced, but not yet has been made into the trial. So from they are continuously dragging your Lordship. From the initial of the case also, they filed the suit was filed in the year 2022. They filed written statement in the year 2023. After which, when the evidence stage has appeared, they filed.
No, one stay petition is pending, I find.
That has been disposed of, Lordship. I have filed page number 37, page number Lordship 36, the order. That has also been disposed of. Thereafter, which again the evidence stage of evidence was been taken back at 27 January 2025. But since then, they are also taking.
Your evidence is over.
My evidence is over. Therefore,
where from I'll get that?
Lordship, at page number 37, Lordship.
Page number 37 of the revisional application.
Of the order, Lordship. I have the it was fixed for PH. I have given my chief as well as the
all the documents were been exhibited, and when the time of cross happened.
Wait. Page number 37, order number 15.
Order number
PW1 did not
Lordship,
turn up.
14, order number 14.
I've seen order number 14. I request you to come to order number 15.
Lordship.
Please.
Today was fixed for cross-examination. Both the parties file and Hajira. PW did not turn.
You did not turn up.
This is the first due to only
After 6 to 2024, what happened?
After 6.
But we will get that.
Lordship, I have also annexed the
certified copy.
Lordship. It is serially there. If you also kindly see at page number from page number 6 of the certified copy. 6 to 24. Thereafter, the matter was fixed for further cross.
As a petition for stay of further proceeding. You did not pay any maintenance.
No, Lordship. I was paying maintenance, but they filed maintenance pending light under section 36 of the special matter, which was been disposed of, which was been rejected by the learned court. The said order I have also been annexed. Your Lordship, it's at page number 41. After being rejecting the said order, the application, again the matter was taken back at the evidence stage. But they consequently twice a day they have prayed for the time.
Where will get that the stay application has been disposed of?
Lordship, page 41 of my application. Order number 7. The said was been Lordship rejected due to non-disclosure of the exact amount of income by the wife on her affidavit, and adverse influence can be drawn, after which the said maintenance pending light was been rejected.
Your evidence is over.
My evidence is at the cross examination on behalf of the respondent. My chief has been filed.
Your cross examination is yet to be completed.
Yet to be complete, Lordship.
How many witnesses will propose to adduce? How many witnesses you want to tender?
That has to take instruction because it has just.
Ashun. By filing
59D of West Bengal Amendment Lordship.
First, tell me which order is under challenge. Which order was under challenge before the learned district judge?
Confiscation order.
Where is that?
Page 17.
Page number?
7. Passed by the Regional Forest Officer. Proceeding under section 59A of the Indian Forest Act 19.
Page number 17 to 21, madam?
Yes, doctor. Order number 28. Appeal 2023, Lordship.
59A3.
Yes, Lord. Case of the West Bengal Amendment, Lordship.
Yes, madam.
Page number 61 of Mindful, Lordship.
Be there as me. 59A I have got.
Forest produced, which is the property of the state government, is produced before any authorized officer under subsection 1. And the authorized officer satisfied that the forest offense has been committed in respect of such property, he may, whether or not prosecution is instituted for the commission of such offense, order confiscation of the property together with the all goods, ropes, chains, vehicles, and the cattle used in committing of the offense. This section indicates there should be a forest offense first.
Then who is the appellate authority against that order?
And it's a 59D. There is a provision of appeal. Any person aggrieved by an order under section 59A or 59C may, within 30 days from the date of the communication to him, such order prefer an appeal to the district judge having jurisdiction over the area in which the property and the tools, ropes, sails, boats, vehicles, or cattle have been seized, and the district judge shall have, after giving the appellate and the officer who passed the order an opportunity of being heard first, an order confirming or modifying or annulling the order appealed against, Lordship. This district judge has the power to hear the appeal, Lordship. We have.
So against an order passed under 59A3,
yes, Lord.
an appeal lies under section 59D.
Yes, Lordship.
So that appeal does not go in your favor.
No, Lordship. That appeal was dismissed, Lordship.
Right.
Against this appeal, we have filed this civil divisional application, Lordship. The order passed by the Regional Forest Officer, Lordship, is completely in infirmity, Lordship.
Very good. Ashok. What has been confiscated, madam?
Truck, Lordship.
Truck. The subject matter of challenge in the instant revisional application is the judgment and order dated 4/9/2024 as passed in Misappeal number 04 of 2023 under section 59 capital D of the Indian Forest Act 1927, hereinafter referred to as the said Act of 1927 in short. Whereby and whereunder learned district judge Darjeeling, while dismissing the said appeal, affirmed the order of confiscation as passed by the opposite party number 2 herein in a proceeding under section 59 capital A within bracket 4 within bracket 4 only or 4 Your matter was kept pass over? No, I'm sorry.
Lordship, in this, Lordship, there was a delay of 65 days, Lordship. On that triggered, application has been filed under litigation at your.
You are for the claimant or the insurance company?
Insurance.
You are agreed with the quantum?
Yes,
Have you served?
Lordship, we have served for the affidavit of service not ready, Lordship. So,
Then I will dismiss your appeal.
Lordship, copy has been already served,
Huh?
already served, Lordship.
Is directed to serve notice under section 5 of the other to file a video. Where we have served? Show me that.
Lordship.
I will dismiss your application.
Lordship, in this matter, Lordship, Mr. Poshuputinath is.
Whoever may be, the order has, whether tell me whether order has been complied with or not.
Sir,
Where it is?
Lordship, I don't have. He installed your phone.
Very good, I am dismissing it.
Tomorrow, Lordship. Lordship, tomorrow, Lordship. Lordship, he will appear, Lordship.
I have seen your lackadaisical attitude on the earlier occasions also.
Lordship.
Whenever these matters comes, you are very reluctant to comply.
No, Lordship, tomorrow he will come.
Let me dismiss 10 or 2 or 20 matters. Everything will be regularized, I am telling you. I know how to do the work.
Advocate and record is Poshuputinath.
Sir, matter is listed today. You have to satisfy that you have complied with the earlier order. That's all. I don't want to hear anything more, sir.
My instruction is that he is served, Lordship, affidavit of service with him.
I'll memorize.
Yes.
I'm keeping it tomorrow.
Yes, Lordship.
And if it is found that it has been served in course of this day, be ready for him getting a cost of rupees 1 lakh.
Lordship,
Be careful, sir.
Lordship, as per his instruction and.
Very good, sir. I have recorded your submission. I'll record your submission. And I'll memorize and keep you in mind that in the event I find that this service is affected today or tomorrow, I will impose a cost of rupees 1 lakh upon you. Take down.
Lordship, Lordship, he stated that he will be in this circuit on Tuesday, on 19th, Lordship. He is practicing at Coachbihar, Lordship. He will available on 19th.
At his whims, I will fix a date.
No, Lordship. I'm just submitting what he stated. So, if the matter can be fixed on 19th.
You are not the advocate on record. Then why are you making submission?
Lordship, I am the instruction counsel. I gave the instruction.
What's your good name, sir?
Shauruk Das.
Mr. Das.
Number 47.
Communicate my anxiety to your advocate, Mr. Nath. Communicate the anxiety and prima facie finding.
Lordship, I am appealing on behalf of the appellant, Lordship.
My lord,
This
Mr.
application for hearing of the section 5 of the Lordship.
You are a claimant.
Lordship, I am on with the, kindly see the last order passed by the Honorable Justice Amrita Sinha on 29/4/2025, Lordship.
How many days delay?
There is an exorbitant delay, Lordship.
How much?
As per my calculation, it is 1108. As per my calculation, Lordship. That is why affidavit in opposition was to be filed by the insurance company, sought for time for 4 weeks. But now 4 months have elapsed, but they have not filed the affidavit in opposition.
My lord, Mr. Pawan Gurung for the Penalty Insurance Company. I am here as a proxy, my lord. He went for his aunt husband's funeral ceremony. So
let him go there.
No issue. Weeks accommodation, my lord.
Ashun. Can 1 of 2024.
Okay, the appear on the item as well. Section 5, Mr. Lordship. Can you see the order, Lordship? Passed by the Honorable Justice Amrita Singh now on 29/4/2025. Direction was given upon the insurance company to file the affidavit in opposition within 4 weeks. But 4 months still has, but they have not filed any affidavit in opposition.
Who's for the insurance company?
Your Lordship, in this matter, I have been appointed by the insurance company in recent past. Your Lordship, if there is a direction that, when was it passed?
On the earlier occasion, Mr. Hiro Burman actually was there.
And subsequent to.
Where is the averment with regard to the delay?
Lordship.
You have not served?
Yes, I have served.
Where is the affidavit service?
Affidavit service, Lordship.
I have received the copy of the application, Your Lordship, for confirmation of delay, Your Lordship. But regarding the same, there is a dispute regarding the council, I believe, Your Lordship, because I have been served with a copy by the insurance
Yeah, the
company.
direction of our Lordship, I have served the copy of the lawyer of the insurance company who appeared last time, Lordship. Mr. Hiro Burman appeared last time. So, as per the direction.
If there is any dispute regarding the same, Your Lordship, kindly keep it not today, Your Lordship. I'll take direction whether Mr. Borman would be appearing or whether I would be appearing, Your Lordship.
But you have been appointed subsequently, right?
Yes, I have been. But if you. If there is any dispute, Your Lordship, he is a senior, so I should respect that, Your Lordship. So kindly keep this matter tomorrow, Your Lordship. I'll take specific direction whether I can appear or Mr. Borman would be appearing, Your
That you
Lordship.
decide, you announce yourself.
Your Lordship, kindly.
The affidavit of services filed today. Can 1 of 2025. The affidavit of services filed
Lordship, I am for that. Lordship, this appeal has been filed within time, Lordship. Lordship. And for the insurance. Lordship. It has been filed within time, Lordship. Can one has been filed for stay of the judgment, Lordship. I'm appearing for stay, Lordship, subject to will submit the award to the registry.
আসুন
can 1 of 2025 disposed of, বুঝলেন? ওটা অ্যাড করে নিন, লিখে নিন। Can 1 of 2025 is thus disposed of. এগুলো না বললে আপনারা করে দেবেন।
Lordship, an application for hearing of the Convention of Your Lordship. Now, Lordship, direction was given by Honorable Justice Shokusachi Bhattacharya to file supplementary affidavit, Lordship. Since some of the grounds taken in the application was not satisfactory. So the direction was given upon the appellant to file a supplementary file. Last reply filed since the lawyer who insurance company was not available on that day. So the matter was not disposed of. Last question.
দেখি ফাইলটা দাও। সাপ্লিমেন্টারি এফিডেভিট কোথায় গো?
First edition file.
Affidavit of service, affidavit of service. Supplementary affidavit. $1,077 days.
1,070.
1882.
No, that's the my that's the stamp board.
Which paragraph is relevant?
5 Lordship.
Which paragraph is relevant?
Paragraph 5 Lordship of application. The application that has been substituted by supplementary affidavit, Lordship. Paragraph 2 of my supplementary affidavit. Please. You have to read.
Yes, what have you got to say?
It will be allowed with our objection. Nothing our
Very good, আসুন। Can one
Matters.
What's your name?
Mr. Govinda Shah.
You are Mr. Saha?
Yes.
এই একবার মিস্টার সাহাকে এটা দেখান। In your presence, the order has been passed.
Lord, what happened, Lordship, actually, number has been wrongly mentioned here. Actually, I have mentioned that. It is fact that I have submitted because since another appeal has been filed on the side of the appellant. This appeal, HDFC, Erico Gealisha has filed the present appeal. But another appeal has been filed on the side of the appellant, Lordship. So that is pending. So my submission was to hear of both the matters analogously.
With this one?
Yes, Lordship. With 54. With 54. 53 is separate matter. 54, Lordship, another matter is that is 66, FMT is 66 by 24. But in place of 66, it has been written 62, Lordship. That is the problem.
এই দেখি কি বলছেন?
It will be 66 only.
It should be 66 of 2024.
That is my opinion. I have filed that appeal.
Bhanu Kumar Rai.
Bhanu Kumar Rai.
That is listed today.
Another one, the cross appeal has been listed today. Bhanu Kumar Rai has not been listed today.
Very good.
My one is 66.
I will take up with this matter later on.
No. So 53 is a separate matter. I am appealing on the appellant. This is fixed for hearing loss.
Where is the paper book?
No.
You do not file paper book in the department?
Lordship, conventional is informal paper.
Even then, it is to be.
Sometimes we file, when we get the notice from the department, we file it before the department.
Huh.
And when we do not receive any notice, so we just make it prepared. So if your Lordship kindly allow me to file it before the court, we file it.
Have you served it to it is all right?
Only some 2-point Lordship. I have come before Lordship for the enhancement of the order.
একটু এমবি একটা দাও। এটা রুলস এই ওই উপরে একটা আছে। Will you please take your seat for some time? Yes, sir. You are agreed with the quantum.
Lord. Okay, past-
Calculation is wrong.
Not as calculation lordship, not in terms of calculation lordship. Actually, notional income actually considered only 5,000 per month. When that
She was not a working lady. No document has been placed.
absolutely, he got a worker.
So he was a homemaker.
It can be taken as homemaker lordship.
No, you have submitted before the trial court.
Lordship,
You are in the trial court.
I will just trial.
Learned lawyer for the claimant has also there is a fact that there is no document of income on record.
No.
But the learned tribunal may gauge the same in the prevailing daily wage rate as well as market price, and after taking note of the daily household work for the family member at the time of fixing monthly income.
So my submission, lordship. So my submission, I have mentioned in the column number 3, that is in column number 4 of my application before the learned tribunal, lordship, that this is used to earn a sum of rupees 9,000 per month. So since she was a tea garden worker, I have mentioned it categorically in my claim application that she was a tea garden worker. So keeping in mind that daily wages of the tea garden worker.
But you have not submitted any document with regard to her employment.
I could, because they are casual laborers. So in the tea garden workers, every now and then they are joining and leaving. So their life in the tribe.
No, some voucher or something has to be proved.
Nothing is there, lordship. In that regard, lordship, if your lordship allow me, lordship, I can rely upon the decision of the honorable apex court, lordship.
Yes, rely.
No. The judgment passed by the Honorable Supreme Court, right? May hand over the copy of. So for the observation of the Honorable Apex Court, lordship.
So far the notional income is concerned,
Lordship.
in the case of Lakshmi Devi versus Muhammad Tabbar,
That is the year 2008, lordship. But this
absolutely 2008.
Lordship.
Thereafter, any enhancement has been done.
There are canon of judgments of the Honorable Supreme Court, lordship. So I'm just right now the judgment I have in hand, that is judgment passed in the case of Sadiq and others versus Divisional Manager, United Indian Insurance Company Limited, lordship. This judgment was reported in SCC in the year 2014, lordship. So may I take your lordship? May I take your lordship to para number 8 of the judgment, lordship?